Hello and welcome to this webinar on employment law for personal injury lawyers. My name's Emma Soul. I'm a barrister with this year 20 years worth of practice. In terms of my own experience and background, my pupillage was employment law purely. I then in my early years did a lot of personal injury. It's left me fortuitously in a position which I think is relatively unique, meaning I can advise clients in those cases where there are dual issues covering both employment law and personal injury. From my practice, I've noticed over the years a real crossover between these two areas, and so the position I find myself in is, as I say, fortuitous. In this webinar, we will focus on a number of issues. Firstly, why does employment law matter? Why should it matter to a personal injury lawyer? We'll look at employer duties, employment claims, vicarious liability, damages in employment claims, concurrent jurisdiction and forum selection, and then we'll go through a worked example. At the end of this webinar, there'll be a short Q&A document. You'll be asked 4 questions. The aim of that is to ensure that I've delivered the content properly and it's been received. So why does or why should employment law matter to a personal injury lawyer? Well, simply because of the close connection between the two worlds. Employment law and personal injury are intertwined. Perhaps the most obvious example of that are workplace stress claims. Once the stress has developed into a diagnosable psychiatric illness, a personal injury lawyer will automatically look at cases like Hatton and Barber to consider whether a personal injury claim is viable. From an employment law perspective, however, there may be matters leading up to that crystallisation which have led to or could lead to an employment law claim. Discrimination or detriment, for example, resulting in a potential claim for injury to feelings even before we get to the diagnosable psychiatric illness. Similarly, in workplace accidents, once an accident happens, of course, a personal injury lawyer is there to assist, but prior to then, is there perhaps a claim for reasonable adjustments in relation to this particular employee? And if so, we could prevent the accident happening in the first place, but potentially there are claims which crystallise under the Equality Act.